I mean, to me, it felt so clear and so obvious who Lily should be, but I also felt deeply protective of her from the moment that I read her story. That, like, if she was interpreted in any other way other than how I saw her, that would have been very upsetting to me as a fan, as an audience member, which I imagine is how all fans feel.
Hey friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. Well, Subpoena sham lawsuit, the Van sham lawsuit, response is in. Baldoni's team, Bryan Freedman and attorneys have filed their response. And their response is not a response. It's actually an amended complaint against Stephanie Jones. And amended complaints were filed by Wayfair Studios and Jennifer Abel. These responses are going to blow your mind because it's definitely not anything I even considered. And I hadn't heard a single attorney that was talking on any of the TikToks or any of the YouTube channels even mention these topics. I think none of us even thought that this could be an option. And what Jennifer Abel is alleging against Stephanie Jones, due to the fact of this uncovered sham lawsuit, is exposure that's not only civil, but has sort of this underlying layer of possible criminal liability here. And this could be why one of Stephanie's attorneys, Kristen Taylor, whose practice focuses on criminal cases, mostly not civil. She does complex civil cases that involve crimes, but the bulk of her practice is criminal litigation, criminal defense. So Stephanie having a criminal defense attorney on her case kind of made people feel like, why, what is going on here? Did she commit crimes? Well, according to Wayfair, they think she might have. So this new lawsuit is filed after she answers the claims against her that Stephanie filed. Okay. And she has added a couple new defenses. We're not going to really go into that. And a lot of the beginning parts of this new counterclaim filed by Jennifer Abel are very similar to what she filed previously. Now, she removed some of the allegations. She is removing the claim of false imprisonment. And she's also no longer fighting with Stephanie about California law and if it's California or New York law. Those are going to be used as defenses instead of being used in the lawsuit. So they're transferring the claims that she's trying to hold her under New York law for her contract, for her work contract. And instead, Jen's going to use that for her defense. And she has new claims, and a lot of them against Stephanie based on that sham lawsuit. So we've already talked a lot about her claim in the past, but in order to set the stage about her phone and set the stage for their claims, this is what they share. Abel observed the morale among JonesWorks employees was inversely correlated with physical proximity to Jones. Thus, the Los Angeles office was generally a more positive environment from the New York office. Abel was also surprised to learn that in spite of its size, JonesWorks lacked any sort of human resources department or dedicated human resources personnel. Jones instead relied on business affairs personnel and her various chiefs of staff to handle any personal related matters. In part due to lack of human resources departments or grievance reporting structure and fear of backlash from Jones, JonesWorks had a toxic workplace culture in which employees lacking an outlet of or meaningful recourse constantly gossiped and complained amongst themselves and leaned on senior employees for solutions to workplace issues. Unlike most workplaces, JonesWorks also lacked written internal policies, including regarding the uses of electronic devices or an employee handbook. At no point during her employment did she see, hear about, or sign anything of the sort. The only terms governing Abel's employment were set forth in her employment agreements. Because public relations jobs require extensive mobile phone usage, public relation firms often assume the cost of the employee's phones and phone usage. JonesWorks was no exception. While Abel had an Android, Jones offered to switch her to a JonesWorks issued iPhone, which required that she port her existing long-term phone number to the JonesWorks company phone plan. Abel had no problem with this so long as she could retain ownership of her phone number and bring it with her should she leave JonesWorks. Although JonesWorks owned the physical device, it was configured with Abel's personal Apple ID and populated with all of her personal email accounts, photos, text messages, third-party apps. Abel had no concerns about using her JonesWorks issued cell phone freely, and as her sole mobile device, as such practices are common in her industry where pay can be low, and neither Jones nor anyone else at JonesWorks advised her against doing so. JonesWorks did not have any internal policies that prohibited such use, gave it the right to monitor such use, or divested employees of a reasonable expectation of privacy in relation to such use. Thus, Abel had no reason whatsoever to believe that JonesWorks' ownership of the physical device would or could in any way compromise her right to privacy in the personal data or accounts stored on it or accessible from it. JonesWorks would not have any right to access or monitor, for example, her personal email accounts, text messages, photos, or bank accounts. So what they're doing here is they're trying to set up this concept that even though it's an issued device by JonesWorks, there are some laws in federal laws that even though you have an employer phone or even if you're on an employer-based computer, your employer still doesn't have the right to monitor anything that you do personally. So if you go on to in Gmail account, your employer doesn't have the right to monitor your emails from on Gmail. They can monitor your work emails, but not your personal emails. The right of an employer to have an umbrella where they can look at anything that you do while you're at work is not absolute. And that's kind of what they're trying to establish here. There are some things that an employer can access, and there are other things that are not. And what they're saying here is that the personal stuff she was not allowed to access. Some of the federal laws that exist around electronic data, wiretapping, computer fraud, monitoring, and such, they have these exceptions for employers. If an employer has a policy about accessing information of an employees or monitoring information of an employees, or if an employee gives them consent to monitor their private information, this would be an exception that sort of shields the employer from criminal or civil liability. And what Jen is trying to set up here is that she's saying that JonesWorks didn't have any policies regarding that and that she never consented for her private information to be violated. So what we're going to have to figure out is what were the private messages? Were they the private text messages? Were some of these emails that were being shared in Stephanie's complaint and in Blake's complaint coming from Jen's private Gmail account? And Jen is going to be relying on the fact that she claims she was given an assurance that when she ported her phone number in 2020 to a JonesWorks phone, that she was given the assurance that they would give her phone number back. So it says in her final week, Abel contacted Jones' chief of staff, Gordon Duran, concerning the release of her phone number and transfer of her personal data upon her departure. As previously discussed, she had ported her existing phone number that she'd used since high school and switched it to JonesWorks' issued iPhone, knowing that she would have to turn over the physical device upon her departure. She arranged for her phone number to be released so she could port it to a new device, retain decades worth of personal contacts, photos, private conversations with friends and family, and confidential financial data, access to accounts protected by two-factor authentication. The chief of staff assured her multiple times in writing that JonesWorks would cooperate and uphold their agreement, and at no point during her tenure did she consent to anyone at JonesWorks accessing, reviewing, or monitoring the contents. And what ends up sort of happening is she shares text messages which show the conversations where she's texting the chief of staff. He's saying that, yes, I'll call Verizon, we'll take care of it. And why she wanted to do this was because, according to this complaint, it was because she wanted to be able to port her phone. So when you get a new device, you can take your old device and then you can put it next to your new device. You can transfer everything that's on that phone, like from your iCloud to your new phone. And then once everything is transferred from the old phone to the new phone, then you can take the device that was owned by Jones and just wipe it. Basically, you can delete all the data on it because this is just their physical object. It's not actually the contents of it. belongs to them. It's just the phone that belongs to them. But she's alleging that Jones basically interfered with her ability to transfer it before her employment ended. And even after she handed over the phone, they interfered. So she talks about everything that we talked about before in her previous complaint, being ambushed, lawyers meeting her, having to hand over her phone, being forced to sign documents that she doesn't remember what they said. She was uncomfortable and didn't understand what was going on. Here's some new information. Following the fruitless search of Abel's laptop, Duran demanded that Abel hand over her phone after security was escorted her out of the building. Abel was ordered to provide the passcode, which she was told was solely to facilitate the release of the phone number. While Abel had agreed to provide access to her laptop for a limited search in her presence, she did not consent to and was not asked to consent to a search of the contents of the iPhone. Because Abel had been ambushed, she had not had sufficient warning or time to wipe personal information from the phone, deregister it from her personal iCloud or email accounts, or otherwise secure the vast troves of personal and private data accessible from it. She still had no reason to believe that they would attempt to access such data, or she would not have turned the device over without making prior arrangements to secure it. So that's where she goes to Verizon. They never release it. They're there for 4 hours. She again shares the messages that she sent to them about it. She talks about how within hours, information and her texts are being shared with other employees of Jones Works by Jones to humiliate her and to disparage her and to degrade her. The disclosure by Stephanie Jones to Leslie Sloan has a little bit different of an angle here, and it's interesting. So what they say is that on the same day that she handed over her phone, Sloan, Lively publicist, confirmed as much to Nathan on a phone call that evening. She gloated that based on what she had already seen, Nathan could expect to be sued. And they're saying that these communications were drawn largely from Abel's iCloud, which is accessible through the confiscated iPhone, despite lacking Abel's consent to access, review, or disseminate these communications. Jones and Jones Works were able to do so without difficulty because with the iPhone in hand, they could bypass the password protection that would have otherwise barred their access. And so she's basically saying that they said they were going to need my password for the sole purpose to transfer the phone, not to access my iCloud. So after everything deteriorates, Wayfair basically on the same day, August 21st, fires Jones Works. That's when everything hits the fan, or that's when the breach is made by Stephanie Jones to both Wayfair and to Jen Abel. And at that point, that's when they need to figure this out about how do we cure this problem. And so now we're going to talk about this lawsuit. Accordingly, on September 27th, 2024, working hand in glove with Jones, Jones Works the Lively parties and their counsel at Manat, Phelps, and Phillips. And that's interesting because they're bringing the attorneys in here, Manat, Phelps, and Phillips, not as a party, but saying that these attorneys helped facilitate a sham lawsuit. That's a big thing. That's an ethical concern here. Initiated a sham legal proceeding in New York State Court, Vanzan Inc. versus Doe's 1 through 10 inclusive. They gave it the index number, and it says the sham lawsuit was nothing more than a transparent ploy to obtain subpoena power. The plaintiff, Vanzan Inc., Vanzan, is an inactive corporate entity affiliated with Lively and Reynolds and entirely unrelated to the film or the Wayfair parties. The lawsuit asserts 3 causes of action: breach of contract, breach of implied covenant of good faith and fair dealing, and faithless servant against Doe defendants. The lawsuit does not explain how or why Vanzan was unable to identify the proper defendants, especially in context of a breach of contract. Instead, Vanzan and Manat implausibly claim not to be privy to the identities of its own contractual counterparties or its own employees, contractors, agents, and representatives. The lawsuit is devoid of specific allegations against anyone, much less Abel, relying exclusively on generalized resuscitations of boilerplate legal jargon. Notably, Vanzan never requested the assignment of a judge, substituted the Doe defendants for named parties, or served complaint on any defendant. The only docket entries are the complaint and a notice of dismissal filed on December 19th, 2024, the day before Lively filed her CRD complaint against Wayfair. And the same day the lawsuit was filed, September 27th, 2024, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. Now, if that's true about that claim that she told someone this and that person can be a witness, that is damning in the timeline. That's what my opinion is. Once the lawsuit was filed, the parties used it to issue a subpoena to Jones Work for all data stored on Abel's phone, including private communications from her iCloud and email accounts, as well as potentially privileged information. Since there were no identifiable parties and no party had been served, the subpoenas were issued without notice, depriving Abel any knowledge of the subpoena, much less the opportunity to object. Do you remember how the journalist for the Daily Mail made the comment that he was given specific instructions to not disclose what the subpoena sought by the source? Do you remember that? And Deadline did. They gave some details about what was included in that. So this week's Deadline publishes an article, and they say that the subpoena concerns, refers, relates, and applies to any and all electronic records, data, documents, and communications in your possession, custody, or control collected from a cellular telephone containing the requested information from December 1st, 2022 onward. That's what this subpoena sought. And in this complaint, she says that after this information was disclosed to Lively without a subpoena and without any proper notice of whatever, and Jones handed it over in November, they filed the sham lawsuit to try to cover up. So they say that she filed it to facilitate and cover up Jones' release of the data that she had extracted from Abel's phone and personal accounts under the guise of legal process without risking detection by interested parties such as Abel, who could have intervened to stop the flagrant abusive process. And then they also say that as planned by the parties upon the receipt of the sham subpoena and on August 1st, Jones and Jones Works blithely surrendered the entire contents of Abel's iPhone communications for a second time, creating a veneer of legitimacy and affording Jones and Jones Works plausible deniability once the New York Times came through for Lively. It is on this pretext that Jones and Jones Works counsel later described responding to a court-ordered subpoena. They then link it to an article that was published on December 23rd of 2024 by Variety. And it says, as a result of Jones' malicious scheme, her life has been turned upside down. Her career and her reputation have been destroyed. Her private information is leaked, and her email inbox and social media pages filled with daily streams of death threats and abuse. The backlash against Wayfair and Baldoni has been equally devastating, and it's an unimaginable invasion of her privacy and dignity. It says that Abel lives in fear of what is to come, given the vast troves of personal data in the possession of these hostile actors. So here's where it gets interesting. The first cause of action they take against them is violation of the Computer Fraud and Abuse Act. It's 18 USC 1030. That's the law. This is both a criminal and civil claim. It's the Computer Fraud and Abuse Act, enacted in 1986 as a part of the ECPA, prohibits the intentional accessing without authorization or an excess of authorization of a computer under certain circumstances. And they are going to argue the CFAA provides that it's unlawful to intentionally access a computer without authorization or exceed authorized access. So they give what the definitions are of all the different parts of this claim. And the meat of it is that her private data, including text messages and emails, was stored in host remote server, which is Apple and Google. And they contact protected computers. And a protected computer is defined as a computer which is used in or affecting interstate or foreign commerce or communication or that has moved in or otherwise affects interstate or foreign commerce. And as alleged, Jones and Jones Works intentionally accessed these protected computers knowingly and without authorization or consent, or in a manner that exceeded their authorization, accessed her cloud-based accounts hosted on protected computers, obtained Abel's private data, therefore in violation of the code 1030A2C. The conduct constitutes knowing intent to defraud Abel her personal data and thereby derive financial gain. Abel has suffered harm and injury due to Jones and Jones Works' unauthorized access. In order to apply for this for a civil action, the loss has to be that it impacted one or more persons during a 1-year period, aggregating at least $5,000 in value. And they claim that this loss during a 1-year period within the relevant time frame included her loss of privacy, reputational interest, and control over her personal data, expenditure of funds to regain control over her accounts, and the legal expenses arising directly from the violation have exceeded $5,000. And they say as a result, she's entitled to bring the civil action against her for economic damages, compensatory damages, injunctive, equitable, and all statutory relief, as well as attorney's fees and costs. So, computer fraud, that's a big one. Violations of stored communications, which is another law, and it's 2701. And this is under the Stored Communications Act in 86 and the Electronic Communications Privacy Act of 1986. And this is that creates a civil remedy against any person who intentionally accesses without authorization or intentionally exceeds an authorization to access a facility through which an electronic communication services provided. And here is where they say that Jones Works unlawfully and without authorization accessed, collected, analyzed, derived financial benefit from, and disclosed and disseminated her personal data. Without her knowledge or consent, her data was intentionally intercepted by Jones and Jones Works. Without her knowledge or consent, her data was intentionally accessed and obtained by Jones and Jones Works. As detailed herein, Abel was not aware of and did not consent to Jones or Jones Works obtaining access to or intercepting, disclosing, and disseminating her communications. She violated the SCA 18 USC 2701 by willfully and intentionally accessing private communications and data stored in servers and other electronic facilities without authorization or in excess of authorization. So just because I've given you access and my passcode, I didn't give you access and my passcode to do this, is basically what they're saying. And then they're also suing for federal wiretapping. It's unlawful for any person to intentionally disclose or endeavor to disclose to any other person or to intentionally use or endeavor to use the contents of any wire, oral, or electronic communications, knowing or having reason to know that the communication obtained in violation of this code. So the wiretapping, they say, relates to Jones and Jones Works intercepted in real time, contemporaneous as it was transmitted, the contents of electronic communications transmitted within and from Abel's mobile device, email accounts, and iCloud, including her text messages, and diverted those communications to Jones and Jones Works. As detailed herein, Abel was not aware of and did not consent to Jones or Jones Works' interception of her electronic communications. Abel had reasonable expectation that after her termination from Jones Works, Jones and Jones Works would not serendipitously intercept and divert the electronic communications described above. And further violation of the Federal Wiretapping Act, Jones and Jones Works have intentionally used or endeavored to use the context of the electronic communications described above, knowing or having reason to know that the information was obtained through this interception in violation of this law, and that they use this illicitly obtained content of these electronics communications to inter alia monitor Abel's activities after termination from Jones Works, spy on her conversations with third parties, including Wayfair and Baldoni, interfere with Abel's nascent small business and gain a competitive advantage in relation hereto, harm her career and reputation, cause mental and emotional distress, and share them with hostile third parties, including Lively, Reynolds, Sloan's, and affiliated entities. It says Abel has been damaged by the inception, disclosure, and or use of her communications in violation of the Federal Wiretapping Act and is entitled to appropriate equitable declaratory relief. Damages in the amount determined at trial, assessed as the greater of the or a sum of the actual damages suffered by Abel and any profits made by Jones and Jones Works as a result of the violations. Statutory damages for Abel, of which is greater of $100 per day per violation or $10,000, and attorney's fees. She also seeks compensatory, injunctive, and equitable relief. And then another one she's doing is violations of the federal California Penal Code 502, and this relates to larceny and theft related to data and information, electronic information. And it says that Jones violated the provisions of California Penal Code 502C by doing the following acts: knowingly accessing and without permission obtaining, altering, disseminating, or otherwise using Abel's data, computer system, and computer network in order to devise and execute a scheme and artifice to defraud and deceive and wrongfully control and obtain property and data. Knowingly and without permission, accessing and causing to be accessed, taking and causing or to be taken, copying or causing to be copied, using and causing to be used computer services, namely her personal Gmail account and email account maintained by Abel's business, RWA Communications, and Abel's iCloud data, including her text messages. So she was accessing her personal Gmail and her business Gmail, is the allegation. And that as a result, she suffered damages. And they say that she acted with oppression, fraud, and malice and conscious disregard of her rights. She's also saying that she invaded her privacy by disclosing private information about her to third parties and then disseminating it publicly to humiliate her. So that's one of the claims. Another one is false light. There's another one here called conversion, and that's about the phone number, where she wants her phone number back, and she says she still doesn't have the phone number. There's an intentional distress, negligent infliction of emotional distress, and promissory fraud. The promissory fraud has to do with what happened on August 21st, where she was told by Gordon Duran that she just needed to give over her password for her phone so that they could transfer the phone number and that she could get all of her data over onto the new phone and get the phone number back, which she still has never gotten back. And that she only revealed that because that was the promise that was made and they never made good on promise. And they said that they never intended to perform the promise when it was made public. Instead, through their agent and attorneys, intended to and did dupe Abel into giving up the iPhone and passcode so as to access, copy, and disseminate without authorization the private data stored. And they did this to hurt her. And she said, I only did this because you made this promise and then you abused that promise and used it to harm me. So that's the Abel side of the house. And this video is already getting pretty long. So I think it's pretty interesting when we look at the context of what it is that they're suing. These are all civil claims. They are not criminal claims that are being used. Each one of the statutes, including as relating to the wiretapping and the stored data and the computer fraud, are all being used that have both criminal and civil liabilities. But what I find interesting is that because they're using these that have both criminal and civil liabilities and a California penal code that directly ties to a criminal act, but that has civil remedies, is I wonder if any of this now has been forwarded to the FBI, because computer fraud and wiretapping are extremely serious crimes. I don't know if that's what happened. This is what's being alleged in the allegation. If they have reasonable belief that this is what happened, one would think that they would be then hoping a civil case might turn into criminal charges. And think of it how Cassie sued Diddy and her civil case then becomes a criminal case against Diddy like a year later. Could that happen here? Could there be wire fraud charges? Could she go down for white collar crime? Is that why she's hiring a white collar crime attorney and a defense attorney for her case? I don't know, but it seems like this really did escalate everything. And it went from some of their claims maybe have been a little bit more couched on theory and speculation to now having actual validity. And one, how they defrauded her into handing over her passcode, how they then used information to harm her and to defame her, And there's apparently now a witness that she contacted the same day that lawsuit was filed and said, don't worry, she's not going to be around much longer. If that's true, and if that all happens on the same timeline, and Stephanie and is working with Lively with the sham lawsuit and they concoct it together, that's not looking good, in my opinion. I'm not a lawyer. I'm not here to tell you what the law says. That's just the optics there are bad. After filing the lawsuit, Bryan Freedman gave a statement to TMZ, and he says, quote, in light of the new evidence being uncovered almost daily, it has become imperative to amend our counterclaims against Stephanie Jones and Jones Works. We are not surprised at all that Ms. Jones would instruct her legal team to go on record and mischaracterize the circumstances surrounding the sham subpoena and the Vanzan lawsuit, so impressively uncovered by the passionate group of online sleuths. That was me. Thank you, Bryan Freedman, for the support. I'm not a bot. I'm not on the smear campaign, and I'm definitely not working for them. But did you see how he didn't credit the Daily Mail? He said it was uncovered by the online sleuths because the Daily Mail was handed it. We had to find it ourselves. And then they continued, a cursory reading of the Van Sham lawsuit makes clear that the Lively parties have been caught engaging in their own smear campaign, intentionally circumventing the normal procedures for clearly improper purposes by creating a fake complaint with an unrelated plaintiff and no named defendants, ensuring that no one would know about or object to their attempt to obtain information that they were not entitled to suggest, as Vanzan, Lively and Reynolds do in their secret complaint, that they are unaware of the identities of their own employees and contractual counterparts is a complete joke. We are just starting to scratch the surface of a much broader and more insidious scheme. To be clear, Jones and Jones Works are equally implicated in this misconduct. We reiterate once again that there is not and has never been a smear campaign except for the one being waged by the Lively parties and Miss Jones in collaboration with the New York Times. We will continue to fight to expose and hold accountable the wrongdoers and uncover the truth. So naturally, because he cited the sleuths, i.e., I was the one that uncovered it, their response is to smear me and say this. So her attorney said, the defendant's weak attempt to assemble their own case against Miss Jones amounts to nothing more than a few debunked conspiracy theories and media gimmicks that have no basis in fact or evidence. The indisputable fact remains. The defendants have yet to provide any substantive defense to Miss Jones's case. Everything else is just distraction and noise. So apparently, if you don't believe what they say, we're conspiracy theorists. And I don't know that it's a weak legal claim. You'd have to ask a lawyer. I think they sound pretty clear. I think it's going to survive a motion to dismiss. And I would honestly be surprised if this disclosure and this revelation of the Vanzan situation, if it didn't result in a tip to the FBI. I'm just saying they take wiretapping and, spying on other people and stealing people's communication very seriously. So with that said, we're always here to help. We're always glad to uncover. I'm glad to know that this resulted in changes. We'll have to see how it goes. Again, everything is an allegation at this point. And of course, Stephanie denies it all. And finally, I would just like to reiterate that Baldoni's lawyers, in their arguments to the court, confirmed my reporting on what I believed was what made these lawsuits fake. The facts that there was no judge involved in the case, the fact that they never sought a judge involvement, the fact that there was no named defendants, the fact that the claims did not match what they were seeking from Stephanie, the fact that Justin's company and himself have no ties to Vanzan Inc. How would Jen Abel's phone also be connected to that? And the fact that they did not know who they were looking for. They clearly knew who they were looking for. And of course, Stephanie's attorneys are going to puff their chests out right now and act like everything is fine, but their statements don't sound like attorneys that feel confident. If they felt confident, they wouldn't be pandering to the media the day before or the day of. They know an amended complaint is coming because they were notified ahead of time before it was filed in court. So, what are your thoughts about everything? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.